Trevor Markovich versus Aaron Markovich. Attorney Lisa McNiff for the plaintiff.
Okay. Good morning to everyone. Mr. Markovich, we're going to take some testimony, so we'll need to have you raise your right hand, be sworn in, then we'll proceed. Ms. McNiff, you can proceed when you're ready.
Thank you, Your Honor. Mr. Markovich, do you recall coming to my office and signing a complaint for divorce?
Yes.
And when you signed that complaint for divorce, were all of the allegations in it true?
Yes.
To the best of your knowledge, are they still true?
Yes.
Did you live in Calhoun County for at least 10 days in the state of Michigan for at least 180 days before we filed the complaint for divorce?
Yes, I did.
And to the best of your knowledge, is your wife currently pregnant?
No.
And you have one minor child that was born during this marriage?
Yes.
And has there been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable possibility of reconciliation?
There is, correct.
If the judge were to refuse to sign the judgment of divorce today, could you continue residing with your wife as husband and wife?
No.
To reconcile?
No.
And you've signed a judgment of divorce?
Yes, I have.
And your wife has as well?
I believe so, yes.
And you wish the court to enter that judgment today?
That is correct.
May it please the court.
Thank you. Ms. Markovich, stated that you signed the judgment of divorce. Is that correct?
I am not sure. I was told I just could default it or whatever.
You know what, Your Honor? I think you may be right. I think we did do a default.
Okay.
Not much.
Ma'am, are you contesting or disputing anything?
No, sir, I'm not.
Okay, thank you. Court will find, therefore, that the testimony does establish the statutory basis. There has been a showing, there's been a breakdown of the marital relationship. The defendant has appeared. She has been defaulted, stated that she does not dispute or contest anything. As a result, the court will enter the judgment as submitted in this matter. That will conclude your case. You are divorced. Best of luck to both of you. I hope everything works out. You're free to go. Have a wonderful day.
Yes.
Thank you.
Mr. Kitty is here today after failing to appear before this court on February 5th, 2020. Bond is currently set at $7,075. This is the third bench warrant. He reports that he is employed at R&R Remodeling. Last payment made on this account was in June of 2020. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on July 3rd, 2024 at 8:00 a.m. before this court.
Mr. Kitty, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on July 3rd, 2024 at 8:00 a.m. Are you able to post a bond, sir?
No, I was supposed to get paid today, but I don't have no money right now.
Okay.
If I get a hold of my boss, I might be able to get my paycheck and get some money down here.
Okay.
I'm just stuck right now. I was supposed to go to work today, and I was helping a friend move, and then that's what happened. I didn't even know about the February court date because I'm homeless. I don't have an address, so that's the only reason why I didn't have a court date. I didn't know about it.
Well, the court notes you have a substantial arrearage in this matter, and you haven't paid now in 4 years. So the court's taking all of that into consideration, but I am going to give you a break in this matter. And what I'll do is I'm going to set your bond in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay. Thank you. You're free to go. Have a good day.
8:56 a.m.
Court will note the appearance of Mr. Toth on behalf of the plaintiff, defending appearing in pro per. This matter is before the court on the plaintiff's motion to modify parenting time. Mr. Toth.
Thank you very much, Your Honor. I would first note that I did not receive a reply to our motion from Mr. Klein, so I really have no clue what his position is. But what I can advise the court of, Your Honor, is my client has sole legal and physical custody. For 5 years, she's been employed working from home. Her employer has now mandated that those employees who are in her position within the company are required to work a majority of the time in the office. And there is no office located in Calhoun County or nearby the location in which she is decided to move is a little over 200 miles from Olivet. It's in Indiana, and the present parenting time schedule provides for 2 occurrences, which really are going to be impossible to logistically continue with, and that would be the midweek parenting time and then the beginning of the weekend on Thursday. At the time that the court's judgment was entered, the minor child was of preschool age. He is now 5 years of age and will be beginning his career in the regular school curriculum, which requires 5-day-a-week attendance. He'll be attending a school district near the area in which Ms. Klein relocates. And as a consequence, Your Honor, I think the parenting time schedule in this case, as well as the standard that applies, have both been met. In regard to the standard, it would be the standard identified in the Sands case, because clearly any change in the parenting time schedule as requested by the plaintiff will not alter the established custodial environment. The change will certainly be impacted by the logistics of my client's change in her work status. The parenting time statute clearly identifies those factors which the court must consider. And Your Honor, I would request that in the event that the court scheduled this matter for an evidentiary hearing, that there consideration be given to having that hearing occur prior to the commencement of the school year, which I think everybody would agree would best serve the minor child's interests. Thank you.
Thank you. Mr. Klein, what's your response?
Well, good morning, Your Honor. As a response to this, I was not notified of this until last Tuesday. I did not know anything about being moved or relocating to a different area. I've heard nothing about job, having to relocate for a new job or having to report to work. As Mr. Toast is aware, I'm not currently represented. I am seeking legal counsel, so I would ask that this motion be postponed or set for an evidentiary hearing. I've spoke with a couple attorneys, and I'm seeking legal advice, and I would like to have some representation in this matter.
Okay, that's fine, and you're entitled to. And what the court will do is, I'm going to refer the matter to the referee for an evidentiary hearing. You'll be able to get in faster with the referee than with the court. They'll refer, and then it'll probably take about a month, I would think, before that hearing scheduled. That'll give you sufficient time to get representation.
I appreciate that.
Okay, thank you. You're free to go. Have a good day.
Thank you, Your Honor.
Court will note the
Thank you.
appearance of Ms. McNiff on behalf of you representing the plaintiff in this matter, Ms. McNiff?
I am, Your Honor.
Okay. Hold on a second. Do you have the what this is?
Motion for temporary custody, parenting time, child support, spousal support, and attorney fees.
Okay, was it a renotice?
It was not.
Okay. Okay. The matter is before the court for a motion for temporary custody and additional relief. Ms. McNiff, you can proceed.
Your Honor, these parties have been separated since March, and the reason for the separation was domestic violence, of which the defendant pled guilty. There have been many instances of domestic violence, one in which he was charged, and the plaintiff did ask for that to be dismissed. But throughout the marriage, there's been significant physical, mental, and financial, emotional abuse. The parties have 2 adult children, and they have one 16-year-old who is still in the home. The 16-year-old has expressed a desire to live with both parents on an alternating week basis. And so we are accepting of that. However, we would ask that the court require that defendant not use any corporal punishment on this child. He does have a history of being violent with the children, as well as with plaintiff in this matter. So while I have concerns about that situation, my client does accept the fact that this child wants to spend time with both of the parents. My client does, at the time of filing, did not have employment. She left the home with a few $1,000s, about I believe it was about $7,000 to $8,000. She has an older vehicle, She needs spousal support from the defendant. Defendant is a tenured professor at Albion College. He makes about $75,000. He has taken over all of the finances. He's closed an account. He has moved funds to Nigeria, we believe. My client has absolutely no access to any of the marital funds. And so we are asking for both child support and spousal support in the amount of at least $1,000 per month. In addition, my client hasn't had sufficient funds to be able to pay an engagement fee for me. We're asking for $5,000 for attorney fees. And I outlined in detail in my motion both the law regarding attorney fees. We submitted a budget for my client that indicates that she has expenses per month of about $5,121 and no way to pay those. And again, she has this vehicle that's a 2006 that's kind of on its last legs. She needs to be able to have a vehicle that she can use to transport the minor child and to look for work. If she finds work, she needs to be able to get back and forth to that work. To date, I haven't heard from defendant. We don't have an answer to the complaint. We don't have an answer to this motion. But given the long-term physical, mental, emotional, and financial abuse, we believe that it's appropriate for spousal support. I did also attach a copy of the child or spousal support calculator, the Craig Ross calculator, that indicates that because this is a long-term marriage and there's a significant disparity in income, that permanent alimony would be appropriate. So at this point, we believe that temporary alimony in the amount of $1,000 is appropriate, which is a small amount in comparison to what defendant earns.
Okay, thank you. Sir, what's your response to the motion?
Good morning, Your Honor. Of course, I disagree with all the things the counsel just presented to you. There has never been any kind of corporate punishment or physical abuse of my spouse or the children. The basis of the disagreement has to do with disrespect and not being responsible. I find it very funny that the attorney said that I never responded. They listed all my degrees, but never listed that my wife has a master's degree. But the basis of our argument over years has been leaving jobs and not being responsible for our actions. And this has really now culminated in my oldest son that I got an admission for at where I teach now, Albion College, that she, behind my back, went to get another admission for him in Grand Rapids. This was a guy that struggled in high school. I'm a professor of biology. He wanted to study dentistry. I said, come to Albion College to get your biology degree before to go to dental school. Last year, after getting admission in Albion College, without my knowledge, the car I bought for the son, they left it, went to buy another car. Now the car is being repossessed. Now he has dropped out of college. So it's this disrespect and not being responsible that always cause the problem. And with regards to what they said I pleaded to, it was because of this son that we had a fight here in the house in December over asking where my son was. So she has prevented me from seeing the boy for over a year now. So I'm not an abusive person. And Your Honor, so that you know the height of your responsibility, I even got a job for my wife at Albion College, director of trio program. She hated me for that for a year. The gift I gave to her, she refused to use it. I gave the gift to my sister in Nigeria when I went this January. Your Honor, the counsel should address why she left that job. It was the same stubbornness, the same attitude that I deal with at home that she took to Albion College, that she left after a year, criticizing people she met there that have been working there for decades. So these are the consistent behavior that I fought against. You know, keep a job. Before then, she would leave a job. She won't let me know. Before the Albion College job, she left a job with her best friend in Jackson. I did not know for like a month. She said she was on vacation. And we sat down. Your Honor, ask my wife to show you your 401k. She doesn't. She has never been fired. She always leaves jobs. I've been at this job for 19 years. She has worked here at Albion and Jackson of over 5 different type of jobs. So what is the justification for me to be supporting somebody that is irresponsible? And that is what I'm fighting against now. The same corporal punishment, quote unquote, that the council mentioned was the way I advised my daughter. She now started the job last week as an engineering specialist. She studied engineering. My oldest son is moving from one job to the next. The job he has a job at the bank, my bank, where he left. They won't take him back. He has now flipping burger at Taco Bell. Talking about family finances, we have our individual account. The money over $10,000 that my wife wiped out the day I went for spring break was my salary account, where I got the mortgage from, where I got the refinancing to do the roof. She has her own account. We put our name in both accounts. In fact, I filed a case. I have a case file here because she withdrew over 12,000. Actually, the way she knew my tracking number and card number was I gave a check to my daughter who was in an accident that I insured all the cars. So they sent a check to me. We have a fight over that. She wanted me to give a check to her that doesn't have her name. So I deposited the check in my account. When I was traveling, I said, Shalina, this is the check because Olaide lives in Indiana. Give this check to Olaide. This is the check the insurance issued. She went to the bank, put a stop payment to that. I was charged for that. For that check, almost $5,000. She withdrew 3 different withdrawals that day, over $12,000. The case is with the police station. I called her. I reported that. So, we don't have a joint account. She should show evidence where she has been withdrawing money from that account. When we file taxes, I will pay for the tax filing, and then I will give her half of what we get in return. She had a problem this year because we were owing over $3,000. So I joked. I said, last year you got half of what we got back. This year, when we are owing, give me your own half. She had a fight over that. So financial irresponsibility, not maintaining. She has 2 degrees. She has 1 first degree. She always says she cannot use her degree to work here in Michigan. Our master's degree in education can only work in Ohio. These are things we have to address in mediation. Why she thought she should withdraw almost $12,000 from my account when I was out of town on spring break. Something she's done this before. She went to take a leaf sheet of my check about 10 years ago when we were fighting. And I said, that would be criminal. This is not your account. All of these are verifiable. I will talk to my bank. They will print out all the interaction. So I filed that and I went to the police station. I have the case number that they gave me here for the money she withdrew. Now, you withdrew money March 11. You went to get a house that you cannot afford. Our mortgage is not even up to $1,000. You went to get a whole house, 3-bedroom house for you alone that you are paying $1,000 as the council put in the case they sent to me. Who does that? She has never paid 1 single mortgage or rent since we met in 1999 that we started living together, married in 2000. She can't say it. She will tell me I'm not saying she doesn't pay daycare or something like that. But of all the bills we paid in this house, we've been living in this house for 13 years. The only thing Shalina pays is Semco Energy. She should show the evidence, other bills she paid. So I've been the responsible person out of my checking account. So she talk about me having a CD. I was saving. I make a lot of money teaching I'm teaching the virology class, extra money. So I put that money extra to take advantage of the 5% CD. The money she's saying I'm taking to Nigeria, I have a 86-year-old dad in Nigeria. 70. I told her, she wouldn't have known. I said, Shalina, the exchange rate is, I just opened that account. I'm in Nigeria and I've been living in the US for 30 years. I just opened this account in January. So it's not as if.
Okay, hold on, sir. Hold on.
Yes.
We're getting into a lot of stuff that we're not obviously able to address today. The court is going to schedule an evidentiary hearing in this matter so that we can get all the information. I do want information at that time on all of the accounts that the parties had and what the plaintiff took out of the account, what was left in the account, what maybe the defendant withdrew from the account. And I want to get all that information so that the court has all of the, the facts in this particular case.
Thank you, Honor.
Sir, do you have any dispute with basically having joint custody of your child?
Oh, no, she's a good mom.
Okay.
She's just a disrespectful wife.
Okay.
I have no problem with that. Well, I will put a quote and unquote. a good mother will not intentionally
Okay, sir,
prevent.
I asked you one simple question. I don't
Okay.
need a narrative, okay?
Thank you. Your Honor, can
So-
I address the issue of the legal fees?
Okay, what the court's gonna do is court is gonna grant to the parties temporary joint legal and joint physical custody on an alternating weekly basis with the child. I understand that may change based upon the child's schedule, et cetera, but you can try to work that out. Court would order us support for the child consistent with the income of the defendant in this matter, and the court will impute to the plaintiff at this time income on full-time at $15 per hour. The court will grant on a temporary basis spousal support of $1,000 per month commencing July 1, 2024, and each month thereafter. Hopefully we can get the matter in within a month or so, and then we'll be able to make a determination whether that is appropriate. The court would grant, at least on a temporary, on an interim basis, will grant to the plaintiff contribution towards attorney fees in the amount of $1,500, which will be payable within 30 days of today's date. Again, when we have the hearing, we'll be able to review all of this at that particular time, and we'll be able to get more information. So we will be in contact with you and try to set up a time when we can have the hearing. Obviously, it'll be a limited scope hearing with the parties and any of the information on the bank accounts, et cetera.
Thank you, Your Honor.
Okay.
Can you give me an idea of how long you anticipate that hearing would be for?
You mean when it'll be? How many?
Like a half day, an hour?
I'm probably looking at, we'll probably schedule it on a Wednesday at 2:00, and so you'd have a couple hours probably.
Okay, thank you, Judge.
Okay.
Your Honor, can I have this question, Your Honor?
Sure.
Is this something I can appeal or challenge? Because you did not let me, I intentionally cannot afford an attorney. I don't know why I'm paying for somebody that knows that she cannot afford an attorney and went to get an attorney.
Sir, you can appeal anything that the court rules in this particular matter. Once we have an order, Ms.
Okay.
Gonna have to submit an order. She'll submit that within 7 days of today's date. Then at the time that the order is entered, you have a 21-day appeal period to take the matter to the Court of Appeals. And then we will, again, we'll have the matter in for an evidentiary hearing when we can get more information.
Thank you, Your Honor.
Okay, thank you. You're free to go. Have a good day.
Your Honor,
No, ma'am, you have an attorney. You can talk to Ms. McNiff.
thank you.
2024 at 9:31 a.m.
Court will note the appearance of Mr. Umloff on behalf of plaintiff, Ms. Thomas on behalf of the defendant. This matter is before the court on the defendant's motion for specific parenting time and modification of child support. In this matter, take it from the motion, Ms. Thomas, that you're seeking basically alternating holidays and spring break. I know there were a lot of things that you addressed as it relates to the child support, which we can address when we recalculate that.
Right. Well, Judge, the big thing is even without that, even if that's not the real big thing is that the judgment of divorce says that Mr. Isaacson will have weekends and Ms. Isaacson, now Denton, will have weekdays. So now Ms. Denton is not allowing weekends, and even Mr. Umloff's when he wrote, we got that answer on Friday afternoon. It shows that their last 2 week schedule, they did have that schedule for the last 2 weeks because she wouldn't let them have them. We have to have specificity, what day, what time, so that we can do it. So our understanding of weekend is after school or daycare on Friday until Monday morning when daycare starts. That's the weekend. So that's what but we need specificity because right now they're saying now alternate weekends, and that's not what the order says. That's not what the judgment says. It was just entered in January of this year.
Okay. Why don't we ask Mr. Umloff, what's your position on that?
Our position is if the court is inclined to grant the motion and grant more specific parenting time, we would request that the defendant have parenting time on a schedule of alternating weekends with alternating holidays that do not include school breaks at this time because the minor child is only 3 years old and is not in school. we would request that his father, David Isaacson, for the reasons outlined in my response, not be permitted to be in the presence of the minor child. We would further request that plaintiff mother, if the court is going to order alternating weekends, that her weekends with the child coincide with the weekends that she is not working at her new job. As far as child support is concerned, we are perfectly agreeable with recalculating according to the formula. We do acknowledge my client has gotten a new job since the child support order was entered. I would simply request that I noted in my review of the materials my client provided to me that Ms. Thomas had sent a subpoena to her employer. I would request that I be given time to also send subpoenas relating to the defendant's income to his employer.
Okay. Well, of course, looking at the judgment that was entered in this matter, and it states under parenting time, says 80-20, says River should stay with mom weekly and on weekends with dad. And that's the extent of it. I guess if we want to modify that, you'll need to have more specific modification. The court would provide, it doesn't provide for alternating holidays, which is standard. The court will modify it to provide for alternating holidays, as well as spring break. And although the child's 3 and not in school, I mean, the school breaks, because at some point the kid is going to be in school. And as a result, they don't want to be back here in 2 years and argue about the same thing. So we'll again modify that to provide for the school breaks as well when the child's in school. What happens is it says state that the child will be with mother weekly. So again, and then weekends with dad, it's pretty clear to the court, although it could be more specific, but the court will order that the child will be with the defendant. I'm sorry, that with the
That's correct.
hold on, with the plaintiff, as it says, weekly. So the court will order, I think the parties have been, is it correct, Mr. Umloff, the parties have been doing the Friday through Monday morning?
Lately, most recently, they've been doing it for the defendant father on alternating weekends. I outlined the kind of 2-week period in my response.
Okay.
Yeah,
Well,
can I respond to that? May I respond to that just briefly?
you can, but again, if you contradict the judgment, I'm following the judgment. So
Right. No, but the only reason that the last 2 weeks have been that way is because that's what he was allowed to have. And that's why we need the times. It's important that we have time, so we know what time to pick up and what time to drop off, because they're not agreeing on that. That's the real crux of this.
okay. Well, what we'll do is in this matter, the plaintiff will have, again, the parenting time through the week, and that'll be, when we set it from Monday at 8:00 a.m. through Friday at 6:00 p.m. And then we'll add in the alternating holidays and spring school breaks as well. Court will order that the parties would exchange all current income information. And if they filed 2023 tax returns, they would provide those to the other side within 7 days of today's date. And then we'll leave it up to the attorneys to calculate the amount of support, taking all that into consideration. Anything else, Ms. Thomas?
Nothing, Your Honor. Thank you.
Mr. Umloff?
Yes, a clarification, Your Honor. Will the school break parenting time start when the minor child is in school or immediately? We would, of course, request that it start when he's in school, and I think I stated that in my argument.
Okay. Ms. Thomas, what's your thoughts?
When I set up in our number 9, when I set up the what we believe the parenting schedule should be, I did it based on the family law committee, based upon that's by the time that they're a certain age. So I would ask that it start now. If it's not going to start now, then we would certainly ask for the number of weeks of summer that would coincide with his age.
Okay. Well, the court note, based upon what the parties have had, is it looks like joint physical. The court will start the parenting time now. We won't wait until school to do that.
Thank you.
Okay, Ms. Thomas,
Thank you,
I'll ask if you would prepare the order, submit under 7 day.
Will do. Thank you.
Thank you.
Thank you, Your Honor.
At 9:40 a.m.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff, Ms. Frost on behalf of defendant. This matter is before the court on the defendant's motion for modification of custody, parenting time, and support. Ms. Frost.
Thank you, Your Honor. As the court just noted, we are before the court today on our motion to modify physical custody, parenting time, and child support. The parties to this file were divorced before this honorable court on November 7th of 2022, at which time a custody and parenting time order was put in place. Pursuant to that order, the parties were awarded joint legal and plaintiff was awarded sole physical, with defendant receiving parenting time as the parties agreed. In sum, the defendant was awarded a minimum of 73 overnights per year. From entry of the order, and again, November of 2022 until June of 2023, the parties remained residing together in the marital home, where defendant had full access to any and all parenting time, and so did plaintiff. But since the plaintiff left the marital home in June of last year, the defendant has not been afforded his parenting time. Plaintiff has come forth disputing this motion, stating that there is a default schedule in place that if the party cannot agree, he's still awarded parenting time. But what plaintiff fails to acknowledge is that the default schedule still isn't being followed. Plaintiff's primary argument in her response is that it's the children's choice, or the oldest child is taking the youngest child to defendant's house, or, they have chaotic schedules. And to a degree that the schedules, which I'll touch on, that's fine. But plaintiff is essentially using the children as scapegoats to detract away from the fact that she isn't providing defendant his parenting time. Defendant does pick up the minor children, not every time, but he does pick them up primarily for his parenting time. And he has no issues with them being involved in sports and other activities, but he's not being provided the information from plaintiff or the kids, but primarily plaintiff, because that's her duty to co-parent with defendant, as to what these schedules entail, and that he's going to miss his parenting time, or that he could show up and attend these activities. He's not being provided that. There have been...
Well, Ms. Frost, under 722.30, he has a right to request all that information from the school, so he can request it himself. He doesn't have to rely upon the plaintiff.
And I don't disagree, Your Honor, but I think it circles back to the issue of the fact that plaintiff simply doesn't want to co-parent with him, which is a factor.
I'm saying regardless, he has a right to get that information. He can do it. So the court's not persuaded because she's not providing it, that, again, there's some issue that he is not able to have that information. He can acquire it a different way. And again, that doesn't address the issue before the court. So let's address the motion in this matter.
Understood, Your Honor. Again, our primary focus on the motion is the fact that, we need a modification of that custody and the parenting time in order to be in the best interest of the minor children. The current arrangement in the stipulated order that parenting time is as agreed upon is not working. The children have expressed a desire to spend more time with the defendant, their father, and it's not occurring. And I believe that a interview of the children under the best interest factors would delineate the desire to have more time with him. There has been a change in circumstances since entry of the order. There has been, the normal life changes that Shade v. Wright allows this court to look at to determine if the current parenting time schedule is working or not. The kids are aging. They've moved out of the marital home where they still resided for 7 months after entry of the order. And these issues didn't arise until they moved out of the marital home. Pursuant to the Vadvarga court, there is that proper cause or change in circumstances that would allow this court to conduct a review of the physical custody and parenting time. The current order, and frankly, plaintiff's behavior at her lack of co-parenting in general, and not allowing the full parenting time to be utilized, is having an impact, and is going to have a long-lasting impact on the children if it's not corrected. Pursuant to MCL 722.27a subsection 8, parenting time shall be granted in specific terms if requested by either party at any time. There is not a specific parenting time provision for these parties. It's as agreed upon. There is a default, but the default still is not being followed. These parties the parties and the children would benefit from having a set schedule that this court would enforce. And I think that it's also important to note again that this was a stipulated order reached by the parties. They used the same attorney to help facilitate that. There was never a best interest analysis conducted, nor was there an analysis of the established constitutional environment. And under MCL 722.23, the court is required to evaluate those factors contained within the statute. And then pursuant to Phillips v. Jordan, which is cited at 241 Mich. App 17, the trial courts can't blindly accept the stipulation of the parents, but must independently determine what's in the best interest of the minor child. And that's what needs to happen now. The stipulated order is not working. the children are suffering at the hands of plaintiff, not allowing defendant his proper parenting time, not wanting to co-parent. And it's not fair to the children, especially when they have that desire to have that time with the defendant.
Okay.
Yep.
Ms. Frost, I'm looking at the judgment of divorce in this matter, and you're saying that there's not specific parenting time, but it provides for alternating holidays. It provides for alternating weekends, summer vacation as well. So I guess I'm at a loss as to what it doesn't provide when it states it's right in the judgment.
Again, Your Honor, the initial parenting time is as agreed upon. And if the parties can't agree, then it falls back to that default schedule. And the default schedule is it's not working. It's not being provided. And the plaintiff has looked at it as, we agree with parenting time, but simply doesn't want to agree with any parenting time and doesn't want to follow the default schedule.
Well, then what you need to do is you need to file a motion to show cause as opposed to a modification. Okay, Ms. McNiff, what's your response?
Your Honor, my response is similar to the court's. I think counsel significantly misunderstands the parenting time schedule. There is a specific parenting time schedule. All Mr. Arbogast has to do is show up and pick up the children, which he says he has done. If he doesn't want them to go to church at 9 o'clock on Sundays during his parenting time, he needs to tell them that and keep them with him. This absolutely this motion is completely devoid of any indication that there's been either an ordinary life change or a significant change that would allow this court to re-examine parenting time or custody. As the court indicated, this might be a parenting time violation, but there's no specifics even for that. We would need dates. We would need to know how my client withheld the children from their father, if that in fact is true. We're asking for costs because this motion is completely inappropriate and devoid of any actual factual information that would permit the court to make a determination regarding a change in parenting time or custody.
Okay, thank you. Well, in this matter, no, I don't need anything else, Ms. Frost. In this matter, the court does note that, again, the defendant in the motion does have many generalized and conclusory allegations in this particular matter. The court will note that the plaintiff has addressed many of those allegations in the answer. The court does not find that defendant has set forth proper cause or change in circumstances sufficient to meet the Vodvarka threshold for an evidentiary hearing on custody, so the court will deny that. The court will refer the matter to the referee for a hearing on child support, as that had been addressed in the motion as well. In this matter, the court will reserve on cost and attorney fees. In this particular case, I guess I'll ask Ms. McNiff that you would prepare that order, submit under a 7-day notice of entry.
I will, Your Honor. Your Honor, you previously sent this matter for child support review.
Okay, then we don't need to do that then.
And so are you also denying the request for a modification of parenting time as well as?
Yes, I am at this time. I don't believe that there's sufficient allegations to raise the level to get an evidentiary hearing, so I'm denying that.
Thank you, Your Honor.
Thank you. You're free to go. Have a good day.
Thank you, Your Honor.
At 9:52 a.m.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This is the front of the court's motion to set aside the referee recommendation, which would allow the parties to opt out of paying support through the court. Mr. Magnuson in his motion again identifies that, in fact, public assistance is involved, and the referee was not aware of that when he allowed the parties to opt out. Why don't I go to Ms. Smart first? Ms. Smart, what's your response to the motion?
We don't have any assistance through the state. When I did give birth, he did have Medicaid, but that we don't do food stamps. We don't have Medicaid now. Both of us have the child under our work insurance.
Okay, but there was a birth expense and all of that. Is that correct? It's still owed to the state?
So we've never gotten a bill, so I'm not sure, because this all kicked off when he changed his address.
Okay, Mr. Magnuson, is that kind of the position now? Is there still reimbursement to the state at this point?
Yes, Your Honor.
Okay. See, Ms. Smart, there's still amount owed to reimburse the state, so you're not able to opt out until such time as that's concluded, and then you would be able to opt out at that point.
Would we like, is there like a way like we could get a bill and just pay that off, or does it have to go through child support?
Well, what we'll do is I'll ask Mr. Magnuson to acquire that information, provide it to the parties. And we have no idea how much it is, but again, if he provides that and you're able to pay that, then the court will allow you to remain opted out in front of the court services. If you can't pay it because of however the amount that's involved or something of that nature, then the court would in fact vacate the opt-out order, and then support would have to be paid through the front of the court until such time as that's paid off, and then you could opt out.
Okay.
Okay. Mr. Allen, you have anything questions or anything to add at this point?
Oh, please unmute.
You're on mute, baby.
Is that better?
Yes.
Okay. No questions really. I had insurance on Lincoln when he was born. She had the Medicaid or whatever she had, and we just never received any sort of billing for his birth.
Okay.
So I've just kind of been waiting in limbo, trying to figure out how I'm supposed to pay it or how much needs to be paid.
We'll do this, sir, is again, provide that insurance information to Mr. Magnuson so that he has that. And then he will provide the information as it relates to the amount that, Medicaid paid, et cetera. And then hopefully you can get it resolved through the exchange of that information.
Okay.
Okay. But the court would, so Mr. Magnuson, if you can, again, coordinate and do all that, but the court would grant the motion to vacate the opt-out, again, assuming that, again, we can find out how much, and if the parties can pay it off and reimburse, then we would not need to vacate the, the opt-out language.
I'll track down that information, Your Honor, and communicate with the parties. And depending on the amount, it may be something we can work out as well. So.
Okay. Okay. Mr. Magnuson will be in touch with you. And again, Mr. Allen, if you would provide Mr. Magnuson with that insurance information that you had on the child when he was born.
Yeah.
Okay. Do that within 7 days of today's date, sir. Okay.
Yeah. When can I expect to hear from Mr. Magnuson?
I don't know.
Yeah, it's as soon as I can find out the information, I'll get with you guys. So
okay,
it's sort of up in the air right now.
Okay, thank you. You're free to go. Have a good day.
Thank you.
Thank you.
If I'm not mistaken, I had insurance on Lincoln too when he was born.
9:58 a.m.
This matter is before the court on the plaintiff's motion to extend discovery deadline. I guess in this matter, I'll ask all of I do know we have some other attorneys substituting in. We'll ask defendants, do you have any opposition to extending the discovery through August 26, 2024 as requested in the motion?
Well, Your Honor, I guess I can start with that. Lead Hansman for Schaefer Ready Mix. We spoke to plaintiff's counsel, and generally speaking, we're not opposed to an extension of reasonable discovery, and we even talked about potentially stipulating to that. The problem we're having is that the discovery so far has not been productive, and that's largely because we're not getting the responses we need. Plaintiffs brought this case, and we've been trying to narrow the issues because we're getting closer to our trial date. Discovery was supposed to be winding up, and we should be close to done. I received discovery responses on Friday that were just a series of objections, no documents, non-answers. And so if the plaintiffs here are saying, we need 60 additional days, but they're not giving us anything, I guess my response is we may even need more than 60 days because they have to prove their case and they're just not cooperating with the discovery process.
Okay. Well, you have a right to, again, request and compel, again, disclosure if you wish. I'll go to Mr. Viviano. Any response on the motion? No?
I don't know that Mr. Viviano, are you referring to me, Mr. Pfeiffer?
I don't know. On the caption, I had Mr. Viviano. Again, that's why I said other people are appearing for other parties. So I have no idea who's appearing today.
Well, thank you, Honor. This is John Pfeiffer. I'm on behalf of defendant Kelly, and I've represented him throughout the course of this matter. I think that only plaintiff's counsel is different today than usual.
Okay.
I guess my position on the motion is similar to what was just mentioned by Ms. Hansman. You know, the court set a discovery cutoff date and set a mediation date and set a case evaluation date, and we're approaching trial. And we served our written discovery request in early March, and it took until the end of May to get responses. But the responses were basically nothing. I'll summarize it this way: that they don't have any evidence to support their case. And so we're at the point here where we thought discovery was over with. The counsel for defendant Schaefer has asked for 3 depositions. We intended to participate in those. There have been no requests for depositions by the plaintiff at any point in time. They served written discovery requests early on, which were answered by everybody. The plaintiff answered discovery requests on Friday of last week, which again, is nothing more than objections to the questions repeatedly. Even though between the 2 defendants in this matter, there's been just simple requests for what evidence do you have for each of the allegations, going allegation by allegation. And again, this is a case that deals with as it pertains to my client, an allegation of breach of a non-solicitation of former customer agreement, and they can't produce anything. And we've already had mediation. And now they want to take further discovery, but they're also saying in their motion for discovery that before they can ask for the depositions, they want further written discovery. And so we all know that takes 21 to 28 days. So how are we going to get anything done in 2 months? So I'm afraid that this is just a total and complete fishing expedition with no end in sight. I oppose the request altogether.
Okay. And remaining defendants, so what's your response?
Your Honor, Randy Kleiman. I'm also here on behalf of Schaefer, and I concur with Mr. Ferrick.
Okay. Well, what the court's going to do in this matter, the court obviously wants to give everybody the opportunity. I will extend the discovery through August 26, 2024, but I will not extend it beyond that date. So get it done. And as stated, if the plaintiff is not responding appropriately, maybe it's necessary to do a request to admit, get them on record on that, and then at that point file motions for summary disposition if necessary. So that will be the order. Mr. Bradbury, I'll let you do an order extending discovery through that August 26, 24 date, and also put in the order that the court will not extend it beyond that date.
Your Honor, if I might.
Okay, go ahead.
The plaintiff has named an expert potentially with respect to alleged damages and calculation of damages. If we're going to extend discovery, we would like a specific date for plaintiff to disclose the opinions or any reports of their expert well in advance of the end of discovery and well in advance of deposition dates of that expert. We'd like to propose something like within 15 days of entry of this order, and then if necessary, we have an expert, a rebuttal expert, and then we can disclose our expert's information within 15 days thereafter.
Okay. Why would it be a problem disclosing experts if we know who they are?
The experts have been disclosed. We just haven't received any information with respect to the expert's opinion or any expert information or reports.
Well, do your discovery on that. You're entitled to get that through discovery. So do it at that particular point.
I asked for that back in March, Your Honor, and told that they didn't have anything and they would supplement it. And here we are at the close of discovery and they haven't supplemented it.
Well, okay. Well, we've extended the discovery. That is the drop dead date. And if they don't disclose it within that date, I guess they may not be able to have their expert witness testify.
Great.
But at this point, I guess if the defendants have experts, you probably should disclose that as well, just so you don't get caught in the same situation as the potentially as the plaintiff. So,
Your Honor, if I may, that was Mr. Clayman's point, is that we have disclosed our witness and the expertise of the witness, but it's truly a rebuttal witness to address whatever damage claim or evidence they may at some point in time offer, which we have not seen. So what Randy is trying to do, what Mr. Kleiman has asked for, is that we are given that information timely in this extended discovery purpose, so that we may depose that witness and also have our witness be prepared accordingly.
Okay, well, why don't we do this? We'll just, in the order, the court will order that the parties would disclose, again, the substance of their experts' opinions in this matter, and do it within 14 days of today's date. And that's all the parties, so that, again, you still have time to schedule depositions if you need to do so. And Mr. Bradbury, you can put that in the order extending the discovery.
Understood, Your Honor. Thank you.
You can submit that under 7-day notice of entry. You're free to go. Have a good day.
Thank you.
See you this afternoon, Your Honor.
Yeah, good morning.
At 10:07 a.m.
Court will note the appearance of Mr. Dotson on behalf of plaintiff, Ms. Lesnick on behalf of defendant. This matter is before the court on the defendant's motion for modification of custody, support, and established parenting time. I will tell you, just as I reviewed this, the court states, obviously, we're going to need to have an evidentiary hearing. I can't do it on a motion day and do that. So that would be the intent, is to refer the matter to the referee for an evidentiary hearing. Ms. Lesnick, what's your thought?
Yeah, we did up here, and we had the matter referred related to the party's son. At that time, he didn't wish to make any modifications related to the daughter because things were going well with her. But since the filing of the motion, since our appearance here, they have not gone well. So then he wanted to move forward with getting a specific parenting time schedule and modifying custody related to the daughter.
Okay, Mr. Dotson, what's your position?
So just two things, Your Honor. First, we were made aware of the motion the day that it was filed, and I informed opposing counsel we would not object to it. Send me an order, we can send it to the court, save some judicial resources as well as some attorney time and money.
Okay.
Yet we're here. So we do not object to the referral to friend of the court.
Okay. Okay, the court will refer the matter then to the front of the court at this point, and hopefully you can come up with a schedule that the parties can live with. Thank you.
Your Honor.
You're free to go. Have a good day.
Thank you, Your Honor.
10:10 a.m.
Court will note the appearance of Mr. Magnus on behalf of the front of the court. This is the front of the court's motion to modify order for support and final judgment and UCSO. In this matter, it looks like Mr. Magnuson reviewing the motion that we simply need to set a evidentiary hearing as it relates to Nazaria. Is that correct?
That was really my question, Your Honor. I don't think it would be inappropriate to just set it for a hearing and like, it's a little different situation we have this time, since we had the paternity case, which involved 2 children. Following the entry of that order, genetic testing was requested and it resulted in the exclusion of 1 child. So I think overall that would probably be the appropriate way to go. We'd have a brief hearing and take care of it that way.
We'll set it for a Wednesday, 1:30 hearing, and then hopefully the parties didn't appear today. Hopefully they'll appear then and we get some more information and get it concluded.
Thank you, Your Honor.
Okay, thank you. Have a good day.
Yeah.
10:12 a.m.
Court will note the appearance of Mr. Carroll on behalf of the plaintiff, Mr. Scott on behalf of defendant. This matter is before the court on the defendant's motion to show cause in this particular matter. I guess I'll ask you, Mr. Carroll, are you opposing the motion in this matter? If so, looks like we're going to have an evidentiary hearing.
Well, Judge, what I found is they didn't disclose at all that we had recently been before the court to request a therapist for Kelsey.
Okay.
And at that time, Kelsey had already been not going to Dad's house. And we entered an order that, I think it was the order you entered on May 8th, Judge, that at that point we indicated if she was going to parenting time, she'd be allowed to take a cell phone. So I just thought it was rather disingenuous that they didn't bring that up. And then he's been filing individual complaints with the front of the court. So they actually set a show cause date, Judge, on July 8th anyway. But I think in the end, I thought the goal of the court and everybody was to have this young lady work with a therapist. She's 16, and we brought a motion for a therapist because she was having problems with Dad's house.
Okay.
I would hope we wait for the therapist to get some time under their belt with Kelsey to determine what's the best direction to take.
Okay.
But Your Honor,
Carroll, we did refer the matter for a therapist. Why would it not be appropriate to let the therapist deal with the matter, and then we can have a hearing at that point?
Mr. Carroll or Mr. Scott?
Mr. Carroll, it's Mr. Scott's motion.
Yeah, it's my, yeah. Oh, go ahead, Sean, if you want to.
No, I think exactly, Judge. I agree. I think we should have the therapist work with Kelsey. She's 16 to find out what's going on.
Okay. Mr. Scott, why wouldn't that be appropriate?
Yeah, thank you, Your Honor. First of all, really the facts of this really aren't that disputed. There was a motion for a therapist because the young lady was not liking the rules basically at Dad's house. Dad said, you know, I don't want a therapist. She doesn't need a therapist. She's just not liking what I have. You've ordered the therapist and the therapist is gone, but nobody's moved to modify this court's order at all. The parenting time needs to continue. It's a court order. The defendant has week on, week off parenting time. He's appeared each and every week to pick up the child for parenting time. That order has not been modified, nor has Mr. Carroll or his client even attempted to suggest that that order be modified. The fact that the child's getting therapy, that's great, whatever it is that they need to do, but he doesn't lose his parenting time because the 16-year-old is having therapy.
I understand.
Yeah, and so really, we have 43 days now, Your Honor. We have fees that are being incurred because this order is just being ignored. And just because a 16-year-old decides that she doesn't want to have her cell phone taken away for violations of the rules at Dad's house, or because Mom's encouraging her not to go, we attach to the complaint and request for an order to show cause, where Mom is in fact talking to this child about, hey, do I have to go? Do I have to go? Do I have to go? And Mom's saying, we're working on it. We got stuff filed before the judge, but nobody has sought to change the parenting time. So it's really, I think I attached the Porter case for this court's review, which says, you know, if we don't have the ability to enforce these parenting time orders when there isn't any significant reason why this parenting time shouldn't be being had, other than a 16-year-old saying, I don't want to go because Dad's rules in essence are basically something that I don't agree with. I mean, Your Honor, she's having, apparently she's 16 years old and she's being allowed to be engaged sexually. Her mom has now put her on to the pill. She's also being allowed at 16 years old to go to MSU parties from down there. Dad doesn't agree with that, and so he imposes some structure which is really good for a 16-year-old child. Not to have Mom buck this. He's put rules on the phone, Your Honor, and Mom says, well, I'm just going to get her a phone then so she doesn't have to listen to it. And then she's writing to her. You can see in the text message of the motion that Mr. Kennedy provided that Mom's saying, hide the phone.
Okay. Well, what we're going to do is the court does want the therapy to proceed in this matter, and that'll help the court discern what the problem is in the case. I am going to the matter with the referee that was set for it relates to child support, so that can proceed. What the court will do is we want to get from the therapist probably sometime in maybe we can get a report from the therapist by August 1 in this matter, and then we could schedule the matter in before sometime in August before school starts, and hopefully get the matter resolved. At that point, I would state in this matter, court will have the plaintiff appear in person in this matter for that evidentiary hearing. And I will let the plaintiff know, ma'am, you have a responsibility as a parent to make sure that the child, again, that the parenting time does go as ordered in this matter. And the court can, not saying I will, but the court can have you incarcerated until such time as that happens. So I want you to be aware of that, that as we proceed, that is a possible remedy. It's for you to go to jail until such time as you turn the child over. So,
well, we asked also in the motion, Your Honor, that pursuant to the Casberg versus Casberg decision, just basically what the court just said, that the mom be given an affirmative duty to ensure that the parenting time happens. If she was not wanting to go to school, Your Honor, she would take some disciplinary measures to make sure that she's going to school, taking away privileges or something like that. That's what a parent does. This child isn't being beat. This child isn't being, this child is not, I didn't interrupt you, Mr. Carroll. This child is not being hurt or anything else like that. She has a disagreement with her dad about the rules that dad's imposing, which,
okay. Well,
which had.
Okay, hopefully the, again, that admonition to the plaintiff will assist her in proceeding and following the orders, and if not, then we'll have to address that at the evidentiary hearing.
And Judge, just so the court's aware too, and I know counsel may have misspoke, Mr. did not show up on at least one of the occasions. On another occasion, they were picking her up from school and she's 16 and doesn't go with stepmom. So I understand, and I have a good sense of what the court's saying. I want to hear from the therapist as well, but we adamantly disagree with a lot of dad's views in this particular thing. I think he just decides he wants to blame mom for things that are going on at his house.
Well, I understand, and we'll address that at the evidentiary hearing if we have to, but at this point, just making sure that mom does attempt to facilitate that parenting time. And I know she doesn't want to go to jail. Court doesn't want to have her go to jail, but I will tell you, when parents have not attempted to facilitate that, I have put parents in jail for that. So just so you know.
No, we don't need her to go to jail.
We appreciate that.
We don't need her to go to jail, but Your Honor, I know that's a relief that's available. We just want to have parenting time to occur. And if it's going to be that contemptuous, then that seems to be a last resort. But there's an affirmative duty that she can encourage and provide some disciplinary measures that she's going to have to adhere to if she doesn't go.
Okay. Well, I think we've addressed that. I'm not going to rehash it.
Okay.
That will be what the court orders, and you're free to go. Have a good day.
Yeah, you too, Judge. Thank you.
All right. Thank you, Your Honor.
24 at 10:35 a.m.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court on the front of the court's motion to show cause. Court had entered a order for genetic testing back on March 25, 2024. The plaintiff failed to appear for the testing on the April 26, 2024 date. In this matter, have you had any other additional response from anyone, Mr. Magnuson?
There was a phone call from her last week and I returned it and advised her of the date and time of this hearing. And she indicated that she essentially didn't see the need for genetic testing, and I got the clear impression she was not going to comply. Now, I did believe she would appear today, but obviously she's decided otherwise.
Okay. Well, what I'll do, Mr. Magnuson, is I'll let you get an order for a new date for testing.
Okay.
Set that alternate date in the order. Also state that in the event that the plaintiff does not show for that genetic testing, that the court would suspend all public assistance available to her until such time as she does comply with the orders of the court.
Very good, Your Honor. I'll prepare that.
Okay, thank you.
Thank you.
24 at 10:37 a.m.
This matter is before the court on the plaintiff's motion to determine child born out of wedlock, as well as to join the defendant, Alexander Jonathan Panetta, as well as waive the waiting period. Ms. Remy, what we have to do is, again, I do note that, again, you had stated in your petition you had not had any contact with defendants since 2019. So the court wouldn't need to do genetic testing on him. Obviously, he couldn't be the father if you've had no contact. Had you done or anticipated any any testing with Mr. Panetta?
So I live with Alex. We've had this discussion. He said if we need to do the testing, which is what was assumed in this case, he is happy and to take part in the testing.
Well, if he comes, what we're going to have to do, I don't take testimony on these Monday hearings, so we'll have to set it for a Wednesday at 1:30.
Okay.
If Mr. Panetta shows up at that time and acknowledges that he's the father, then I don't need to do the testing. I just didn't know. I didn't know any of that as to. So I guess at this point, what I'll do is after this hearing later today, when you can get to my office, because we're in hearings, we've got another hearing after this at 11. Contact my office. We'll set you up for a hearing 1:30 on a Wednesday, and then we can take some testimony. It doesn't take long. It takes about 15 minutes. And then we will be able to address all of the motions at that time. And if Mr. Panetta is there as well, we can address and take care of that.
Okay.
Okay?
Okay.
Anything else, ma'am?
Versus Gregory Edwards.
No, Your Honor. Thank you so
Attorney
much.
Kevin Sacramento.
Okay, thank you.
On behalf of the Public Defender's Office.
Okay. Good morning to everyone in this matter. I guess I'll start, Mr. Sackrider, just in this matter, I guess I'll start this matters before the court on the plaintiff's motion to show cause for violation of a personal protective order. And I don't recall in looking at the file, had we already done the arraignment in this matter or what? Do you know?
I do not, Your Honor.
Okay. Mr. Edwards, I don't recall doing that. Do you know, did we do a arraignment previously? If you can look that up.
Not to, let me double check. I don't believe so.
This is the first time I've appeared.
Oh, this is your first time, sir?
Yes.
Okay. Well, if it's your first time, we have not done the arraignment. I'll go through that with you. In this particular matter, obviously we're here upon the motion to show cause, and the petitioner is claiming that you violated the personal protective order in this matter, and she's alleged in this matter that you were outside her home on Tuesday, June 4, 2024, that okay, that again, that I've got to go to the next page. That then on June 7, 2024, that you've been stalking her by driving by her house several times. And that at some point that it says, she says you told her that where she was and who she was with, etc. You have a right to, again, contest the charges in this matter. You have a right to attorney. Attorney has been appointed to represent you with Mr. Sackrider. You have the right to remain silent, not have your silence used against you. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to confront witnesses. You have the right to call witnesses if you cannot get those witnesses to appear, and that you can ask that the court would compel those witnesses to appear on your behalf. Mr. Sackrider, I take it in this matter that it's your client's intent to plead not guilty in this matter. Is that correct?
That's my understanding, Your Honor.
Okay. And so the matter was set. Mr. Sackrider, are you ready to proceed on the violation hearing today, or did you need additional time to do that?
I would ask for statutory adjournment to meet with my client, file an appearance, and subpoena any witnesses.
Okay. Ms. Edwards, you understand what they're asking for?
Yes, Your Honor.
Okay. Well, he has a right to, again, just being pointed, he has a right to, again, the court does, because we had not done the arraignment previously, he has a right to that additional time to prepare the case. So the court will grant the request for an adjournment in this matter. We will be in touch with you, and Mr. Sackrider and Ms. Edwards will be in touch with you as well to see an alternate date that we would be able to come in and hear the matter. So you're free to go now, and we'll be in touch with you and set up another date. Okay?
All right. Thank you.
Okay. Thank you.
Thank you, Your Honor.
Have a good day.
PM. This is case number 2024-1030 CB, Ferguson Enterprises versus Running Right and 4 other defendants. Attorney Mahoney for the plaintiff, Attorney Brian Marcus for defendant number 2, Attorney Lara Ward for defendant number 4, and I do not have Attorney Applebaum for defendant number 5.
Okay, I'll start. Good afternoon, and start with you, Ms. Mahoney. Enlighten me. What's happening in your case?
Good afternoon, Judge. It's not a very complicated case. I have served all the parties. I don't know why Mr. Applebaum's not here. Running Right was the entity whose account was used to purchase the goods. All of the goods are in the possession of Mr. Marcus's client, but Mr. Marcus's client has chosen to keep the goods and not pay for them. And I apologize, Brian, I know you and I have talked about this case, but that's virtually how I see it, is that they've got the goods and don't want to pay for them, and it could be easily resolved if they just tell us what they would like to do.
Okay. Mr. Marcus, could you give us some insight?
Yeah, sorry, my camera's not working very well.
That's
so I turned it
fine.
off. But yeah, that was the case previously, Mary, and I have talked about this, and in other cases we've gotten along real well. That was the case, but I believe that my client does now want to enter into a payment structure to get payments made relatively quickly to get this this moved. And we do have the equipment. We do now want it. It looks like we want to make some payments.
Okay. Well, Ms. Mahoney, maybe you need to speak to Mr. Marcus at that sometime. Now we've gone through the impasse and that you can come to some resolution. I don't know.
Yeah, that would be my hope, Judge.
If you're available, I'm still good. Rest of the afternoon kind of thing. We could have a chat and start that ball rolling.
Let's do it.
Okay. Ms. Ward, how are you involved now?
Well, we represent the bank itself, and we have a loan out to the entity that has possession of these dehumidifiers. So,
okay,
they're in the chain of title, Judge. That's their whole place in the case.
Yeah. Okay. And does anybody know why Mr. Applebaum is not here?
He's a secondary lender, AMJ Partners, and I'm assuming he's not here because he has forgotten about it, or I know that I'm looking at our records and I see that we did send a copy of the notice.
If I may jump in real quick, I do remember from our last hearing that I thought Alan said that he was like somehow he's like not interested really in the case because he was only a secondary player, and that if it would be okay, he didn't have to appear. Something like that strikes me as familiar. I could be wrong, but I think that was what it was.
My earlier conversation with him was just that he's his only place in the case is to establish his secondary priority. So I think the bank is first, and then Applebaum would be second. And then Running Right, I did give them an extension on answering. They feel that there's a lot of unfairness as to them being in the case because they were just a middleman, essentially.
Yeah. Well, maybe you have to enlighten them and say, don't get in the middle of these things.
Yeah, exactly.
Okay. Well, I'll let you have a little bit of time. What I'd like, at least for the three of you, is to talk. And if you basically, if you can't come to a resolution, get back to us in about, let's say 14 days and inform us of a mediator that you've been able to agree upon, and then set mediation in this matter.
I think that's a good idea, Judge. I don't think this is a very discovery intensive case. I think all the parties have all the documents that are involved here. If Ms. Ward doesn't have them, I'm happy to forward those along to her. So I think your idea is very well taken, that we could probably sit down with the assistance of somebody and get this whole thing just resolved.
Okay. So what we'll do is we'll be in contact with you after the 14 days, give you that time. If you do end up agreeing upon a mediator and a date, contact my office, let us know when that is, and then we won't have to drag you back in just to find that out.
If I could, Judge, would we just be able to submit a stipulated order?
Oh, sure.
Sending it to mediation with a specific mediator in mind?
That would be great.
Okay.
Okay. Anything else, Ms. Mahoney?
Nothing further from the plaintiff, Judge.
Mr. Marcus?
Nothing further either. Thank you.
Ms. Ward?
Nothing further, Judge. Thank you.
Thank you, and free to go. Have a good afternoon.
Thank you, Judge. You as well.
Attorney Bradbury for the plaintiffs, Attorney Hansman for the first defendant, Attorney Piper for the second defendant. The actual defendants themselves are here, Schaefer and Kelly.
Okay. Good afternoon, and I'm sorry to drag you in. I didn't realize until after the hearing this morning that we had this afternoon, and if I had, I would have taken care of it at that time to not have to bring you back in, because I don't think that things would change since we were here this morning, and I got a good idea at that time what your issues are, and I don't think there's anything else other than what happened this morning. Is that correct, Mr. Bradbury?
Yeah, thank you, Your Honor. And also apologies. I think I had this as at 1:30 on my calendar. And so if I was the one who kept everybody waiting, sincere apologies. No, from my perspective, I think I don't think things have changed. Although, there may be some loose ends to tie up in terms of the few depositions that have been noticed, which defense counsel and I had been discussing possibly rescheduling. They were noticed for this week. As the court is aware, discovery has been extended, and our position was and is that the convenience of witnesses and for the convenience, frankly, of counsel, plaintiff's counsel anyway, as well, setting those in mid to later July as opposed to this week would just be more convenient. It would make more sense and would allow us time to review the motion that we received last week regarding the discovery responses that we submitted to Schaefer on the 21st.
Okay, thank you. Mr. Paparik, what's your position at this point?
I think one item we should, thank you, Honor, John Pfeiffer on behalf of Gary Kelly. We have a case evaluation coming up in August, which would be before the close of the newly imposed discovery deadline. I'm wondering if we want to set that back, or another item I would talk about case evaluation is whether or not this is a case that should go to case evaluation.
Well, Ms. Hansman, what's your position?
I believe the case evaluation is actually much sooner than that. I'm showing case evaluation on July 18th, which, given how little effective discovery we've had, I'm not sure how productive case evaluation is going to be. So I'm inclined to agree with Mr. Pfeiffer on that one.
Okay. Well, why don't we do this? Why don't we adjourn that case evaluation? Quite frankly, I find that mediation is much more effective than case evaluation. So I guess what I'll do is I'll set another status conference at the conclusion right after discovery ends. And at that time, I guess I would ask that all of you would have gotten together before that and agreed upon a mediator and to get a mediation date as well after your discovery cutoff date.
Your Honor, if I may, one of the things we pointed out this morning was that we've already had mediation.
Okay. Well, I didn't know if you were, once the discovery went through, if you were going to additionally do some more round of mediation or not. So maybe you can light me there.
From plaintiff's perspective, Your Honor, I'm not sure that it's been decided. However, I think we came away from mediation with the thought and the understanding that additional discovery was probably necessary in order to have hopefully more productive settlement conversations, whether through a mediator or otherwise. Of course, I think through a mediator would probably be the most productive avenue.
Okay. What are the thoughts from the defendants? Counsel?
Let's put it this way. I didn't leave the mediation thinking that we were going to continue on with another session.
Okay.
And personally, I'm always in favor of mediation, but we spent the better part of a day here just a couple weeks ago, and it was fruitless.
Okay.
Mr.
Kleiman, we hadn't asked for any input from you. What are your thoughts?
You're still muted, sir.
You have to unmute, sir.
Sorry, Your Honor. I just joined, so I'll wait for a second to catch up, but Ms. Hansman could certainly speak for defendant Schaefer Ready Mix.
I concur with Mr. Piperick. I did not leave mediation feeling like that was particularly productive, and I don't know, perhaps plaintiff feels that, additional discovery will move them on their settlement position. If so, I suppose that's something to consider, but I think that's not going to change much for us.
Okay. Well, at this point, what we'll do is leave that open as well, unfortunately, and we will set a settlement conference following the end of discovery. And if you all wish to get back together and try to mediate again, fine. If not, when we come back for the settlement conference, we will set a trial date at that time.
I do have one question, Your Honor, from a scheduling perspective. I've been looking at the dates in the scheduling order with the extension of discovery. My concern would be the date for motions, because we anticipate filing a motion for summary disposition. And if discovery is now through August 26th, that doesn't leave a whole lot of time if Your Honor wants them to be scheduled and heard by the end of September. So I'm wondering if that date need also be moved.
Well, I would think by the time that discovery is done, you would have an idea at that point whether you're going to file for summary disposition, don't you? I just wonder why we would have to move it if you have effectively a month after the conclusion of discovery. You could get your motion in and we could have it heard by the end of the September.
As long as that's something that's not going to present a problem with your docket, Your Honor. A lot of times I've had judges say that if it has to be heard by that date, it needs to be filed well in advance of that date to ensure that your hearing is timely. So if you're not concerned that we'll have enough time as, to file a C-10 motion at the close of discovery and have it heard before that deadline, I'm okay with that.
No, we can have that done. And in fact, what we do is we set those hearings in business court cases on Wednesday afternoon at 2:00, so that we give you sufficient time to, again, argue the motion, especially with as many attorneys as we have involved. That would give us the rest of the afternoon on that day. Just, again, set it for whatever that date would be. And you're probably looking at September 25th would be the last Wednesday in September. And you could set it for 2:00 p.m. If that doesn't work, contact my office. We could move it to October 2nd, but I guess I'd say one of those two dates. And obviously, if we move that to the 2nd, then that would amend the case scheduling order then.
I think both of them would, because I show our cutoff date as September 24th.
Oh, okay. Well, what we'll do is I'll leave that up to the defendants, but Ms. Hansman, why don't you do this, is do an order saying that the summary disposition motions deadline is extended to October 2nd. And then that way we get the 2nd date or the 25th, whatever you can work into that.
Sounds good, Your Honor. Thank you.
Okay. Anything else that we can do for you, Mr. Bradbury?
Just the first issue that I raised, Your Honor, in terms of deposition scheduling. I mean, would you like the parties to work together in terms of rescheduling the deps that have been noticed for this week? Or just looking for a little guidance and relief there, I suppose.
You're not gonna get a lot of guidance because I try not to get involved in discovery matters unless I have to, unless motions are filed. So obviously it would make sense for all of you to come to some amiable agreement if you could. If not, then you're unfortunately maybe stuck with what's already been done. So.
All right, understood, Your Honor. Thank you.
Okay. Mr. Barrick, what's your thoughts?
I've
Anything?
got nothing further, Your Honor. Thank you.
Okay. Ms. Hansman?
I have nothing further either, Your Honor.
Okay, Mr. Kleinman?
I'm good, Your Honor. Thank you.
Okay. Thank you all again, and have a wonderful afternoon.
Thank you.
Thank you.